Good afternoon and welcome to the Appellate Division, First Department. I will let you know that we have more than 6.5 hours of argument time requested. So I'm going to ask counsel to ask for the time that you need, not the time that you want. Please know that this court is familiar with your case, your briefs, the record, oftentimes more than you wish we were. So, and please know that the time that I allot is a time clock for you, not for the court. So if my colleagues have additional questions, I don't interfere with that. So if you're brilliant, you get extra time, okay? That being said, here's the call of the calendar. People versus Amaro. Submit. Leaf versus Leaf. Okay. Which side are you on? Respondent. Okay. It seems the appellant has been scared off. Do you wish to submit? Okay. Thank you. You can have a seat until the call of the calendar and then you can leave. Okay? Amanda R. versus Michael R. is a submit. HSBC Bank versus Min. 5 and what? 5 minutes. Anyone else? Okay. I will give you 3 minutes since you have no opponent, and if my colleagues have more questions, we will ask them. Okay. Golden versus Echo Health Alliance. Okay. Okay, 5 and 2 and 5. People versus Jason Cruz. Submitted. People versus Luis Guzman. Submitted. 979 Second Avenue versus Chow. Okay. This is Ms. Chow. Okay. How much time, ma'am? Okay, I will give you 4 and 1 and 5. I understand. An adjournment request was made, as you know. It was a repeat, identical request as the last one, and that request was summarily denied. We are moving forward with argument. Okay? All right. Moore versus Scanza. Okay. 5 and 1 and 6. People versus Kevin Williams. Okay. 5 and 2 and 5. Kirby Forensic Psychiatric versus Myron M. Okay. 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 All right. 6 and 1, 6 and 2. Okay. DeWald versus Mass Mutual Metro. Okay, and how much time? 5 and 1 and 5. This is not complicated. People versus Kai Lee. Okay, 2 minutes. 2 and 2. Soloway versus, that's the next one. Soloway versus Sim Group. Okay. You scared away the respondent. How much time would you like, or would you like to submit? You got it, 3 minutes. Brunwasser versus Estate of Rhonda Scharf.
For the respondent, Your Honor, I'll rely on submission of my papers.
Okay, submit it. Pafanis versus A.O. Smith Water. Okay.
Respondent request 5.
6 and 2 and 5. People versus Efrain Vasquez. Submitted. Thompson versus Nelson is submitted. First case argued on the calendar is HSBC Bank versus Min. Oh, I'm sorry. We'll call you next. DeWalt versus Mass Mutual is being called out of turn, and the appellant has submitted a video for his argument. Okay, we will hear that video now.
May it please the court. I come here today a humble pro se
All right.
before a panel of 5 distinguished justices.
Is this, hold on. Is that counsel for the case?
I generated that.
I'm sorry?
I generated that? That is not a real person.
Okay, it would have been nice to know that when you made your application. You did not tell me that, sir. I received the application. And you have appeared before this court and been able to testify verbally in the past. You have gone to my clerk's office and held verbal conversations with our staff for over 30 minutes, okay? I don't appreciate being misled. So either you are suffering from an ailment that prevents you from being able to articulate, or you don't. You are not going to use this courtroom as a launch for your business, sir. So if you are able to shut that off. If you want to have oral argument time, you may stand up and give it to me. You have 5 minutes.
You can argue right here, okay?
Your time has started.
Right. May it please the court. My opponent's entire argument relies on a fiction that I somehow agreed to an arbitration clause that was buried deep in a contract. The facts and the law both reveal why this is not true.
Can you please raise the right to you? Okay, go ahead.
May it please the court. I come here today a humble pro se. My opponent is a principal in one of America's largest attorney firms, and his client is a very large insurance company. The question before you is like unraveling a shell game. Which cup is the bean under? Is it contract A, contract B, or contract C? We start with bean under contract B. We all agree the bean was there in the beginning. It has no arbitration clause. Next, an automated system called FieldNet shuffles the cups. My opponent would like you believe that the controlling contract bean ends up under contract A, where there's an arbitration clause. But did it really get there? That's the question before this court. 3 critical facts distinguish this case. First, I began working for Mass Mutual under a fully executed B contract that contained no arbitration clause. This was a complete binding agreement that Mass Mutual now attempts to dismiss as merely a receipt of policies, a clear mischaracterization designed to facilitate their bait and switch. Second, I explicitly refused to falsely represent that I had never been convicted of a felony, as required by paragraph 4 of the A contract. The record conclusively shows my truthful yes answers to the felony questions in FieldNet. Third, after my rejection, someone or something changed those answers without my knowledge, then checked I accept on my behalf and submitted the application. This fact is absolutely undisputed, but my opponent continues to ignore it throughout his pleadings and will likely do so today. This issue alone begs remand for discovery. The lower court's misapplication of Flores rests on 4 fundamental errors. First and fourth proposition that signatures are not required when there's objective evidence of intent to be bound. Here, the evidence shows the opposite. My explicit rejection of paragraph 4 and ongoing performance under the B contract demonstrates I did not intend to be bound by the A contract. Moreover, it's important to note that had my answers before not been changed, management wouldn't have accepted it. So there's no way that the bean can be under cup A. Second, unlike Flores, which involves sophisticated commercial parties of equal power, this case involves complete novices with 0 industry experience. Mass Mutual's attempt to characterize our valid B contract as merely a receipt of policies reveals their strategy. Lure inexperienced recruits in the door on one set of terms and then unilaterally post arbitration later. Third, the constitutional implications of waiving trial rights through arbitration demand a higher scrutiny beyond the mere indemnification provision in Flores. Fourth, compelling arbitration, in this case, contravenes the public interest. When corporate tactics stay hidden in arbitration, they eventually lead to Mangionis and national headlines. The public has a legitimate interest in seeing how contracts are formed, altered, and enforced, particularly when heavily regulated financial institutions like Mass Mutual are involved. These institutions control trillions of dollars of public money and operate under special regulatory privileges. Private arbitration of these issues shields important legal questions like misclassifications of employees from proper judicial scrutiny.
You'll have time on rebuttal. Thank you. You may proceed.
Good afternoon, Your Honors, and may it please the court. I'm going to just address a few points because I do believe our papers really do address many of the allegations.
Was it possible to accept just the B contract?
No, and in fact, on page R29, by respondent's own submission, it states, quote, unquote, and actually even emphasized in the submission that it was required for anyone to perform services for the agency to complete both the upfront contract and the A contract. That is from the motion papers that appellant submitted on his own. And so there's no dispute by either party that both the upfront contract and the A contract were both required in order to perform services for the
If I
entity.
understand the record correctly, your adversary sought assistance in completing this application process and sought the help of the very person who helped him complete the process, correct?
That is correct.
And the evidence with respect to how that application was being put into the computer showed that your adversary attempted to hit submit on several occasions in contravention to his assertion that he never attempted to have that part of the contract admitted.
That is also correct.
I'd like to move to another area, the registration agreement.
Yes.
Now, certainly, for that agreement, there was a box to say, I accept. It was checked. Yes?
Yes.
Okay. And so this registration agreement also had an arbitration clause.
That is also correct.
And so there's no doubt. Well, let me say it this way. There's no, let me find the right word. There's no dispute that plaintiff signed that registration agreement where he agreed to all of the terms, including the arbitration.
Correct. And for clarification, the registration-only agreement comes into play once there is an attempt to sell the FINRA securities-backed securities. So that's not one of the onboarding initial requirements of
I
the
know.
contract, but yet both the A contract and the registration-only contracts with requirements for arbitration do cover the entire scope of services that are being performed by any agent.
You can continue.
I actually, those were the main points that I really wanted to address, especially the fact that both parties do say that the A contract is required. With respect to the attack on the constitutionality and public policy grounds, unless the court has questions about that, I feel that we do not need to address those. I think there's longstanding principles in favor of arbitration. And I think really the facts on page Rs 120 to 123 really do show that there was a manifest intent for the parties to be bound by the contracts, whether or not there's a dispute of it being signed. So as you said, you have a very busy docket today. I'm fine for resting on the papers for the rest of our submissions.
Thank you so much.
Thank you.
Counsel, you have a minute.
Whatever I am. May it please the court. The registration-only contract would be under Cup C, and that contract concerns SEC work. I never worked under that contract, so I don't see how that contract comes into play at all. Can you hear me?
Yes?
So a BB, although it is not a controlling case, I think gives this court some guidance with respect to contract alteration, as the lower court seems to be relying on the A contract to find consent to arbitrate. Here, in a BB, there was an allegation that the contract had the electronic process had flaws in it. Here, we clearly see that the electronic system had problems with it. I never claimed that I did not have felony convictions. I put those in the record. They came back in the signed contract with no answers. I don't know where those no answers came from.
All right, thank you. HSBC Bank versus Min. You may proceed.
Yes, good afternoon, Your Honor. My name is Dong-Sung Kim, appearing for the appellant Ji-yeon Min. This is a foreclosure case the plaintiff filed on October 25, 2019, using the same 9-day notice the plaintiff used in the previous foreclosure action in 2015. The plaintiff's 9-day notice does not contain the statutorily required language and information under RPAPL 13041, especially regarding the homeowner's right to remain the property until the court order and New York State Attorney General's Home Protection Program. The amendment to the RPAPL 1304 in 2016 requiring the inclusion of this statutory information became the law on June 23, 2016, and after the 108 days, the grace period effective as of December 20, 2016, which is almost 3 years prior to plaintiff filing the instance action. So it is obvious that the plaintiff failed to comply with the RPAPL 1304, which is a precondition to commence the foreclosure action. With such reason, the lower court decision to grant plaintiff motion for the summary judgment should be reversed.
Thank you so much. We have no questions. Thank you for your argument and your briefs. All right? Golden versus Eco Health Alliance. You may proceed.
Good afternoon. May it please the court. I am Patricia Finn. Can you hear me now?
Better.
I am Patricia Finn. I'm here today on behalf of the appellants in the matter of Golden versus EcoHealth. We're appealing 2 orders of the trial court. One granting respondents' motion to dismiss, and the other a denial of a CPLR 2221 renewal motion.
Why don't we focus on the first one, since the latter, right? Go ahead.
Indeed, you think so. So I think the important issue here, there's 2 key factors. First, respondent appears to have recasted this case as nothing more than an issue of funding scientific research.
Well, what evidence do you supply to show that it's anything other than funding, other than a bunch of conclusory statements in your complaint, which say they collect, they transmit, they this, they that, but you couch this defendant along with every other actor who's not in this country, right? So explain to me where in your complaint specifically there are actual facts, not conclusions, not conjecture.
I understand
Right?
your question, and I respectfully disagree.
That's nice. Tell me where in your
I'm
complaint.
about to, Your
please.
Honor. Okay, their own evidence, their own contract.
Counsel, my question is,
the complaint.
where in the complaint do I have facts to support it?
Your Honor, the facts are in the complaint to establish.
Tell
the
me
cause.
where they are.
I don't have the complaint with me. I'm here.
I'm sorry, you came here to argue a very important case.
I'll get the complaint. The complaint's back there. Your Honor, there are 7 counts. Each of the counts included evidence. We also provided.
What evidence?
I'm getting to that. We've also provided a copy of the Inspector Grimm,
The Grimm report.
the Grimm report, which clearly said, well, first of all, there was no burden on me to provide evidence.
A complaint has to at least have a bare modicum of facts to support it, not just conclusions.
Okay, so,
So I've asked you about 4 times now, what are the facts? Because again, I can go to the complaint. I printed it,
okay.
right? And let's go to the strict liability claim, because I think it's the only one that has any potential oxygen, right? You talk about those working in furtherance of this enterprise, but there's no facts to support that. Outside of, we gave the Wuhan lab funding sources.
Your Honor, that's completely inaccurate. The plaintiffs themselves, EcoHealth and Peter Dazik, were named in this complaint, and they were the individuals involved in Wuhan. They were involved in the collection and sampling of bat viruses, the manipulation of those bat viruses.
So I get, again, what facts are you pleading to support that?
Fact-
So you're saying on December 31st, this individual defendant was in China collecting and mutating viruses. Is that your allegation?
Excuse me, Your Honor. It was far more than that. It was over a period beginning in 2000.
Okay, so I'm asking you, where is that
In the
allegation?
complaint. They are in the complaint. We allege these 2 defendants were absolutely involved in the collection.
Yes, and you allege it in the most amorphous and unfactually based way. And that's, I think, what we're all trying to struggle with. You have to have a good faith basis, factual basis, to come to a conclusion that someone actually did this. If you are saying this doctor was in the Wuhan lab from this date to this date, is that in the complaint?
Yes, it is.
Where? Show me.
I don't have the complaint.
Well, okay, so we've all read the complaint and we didn't see it, so
Your Honor,
unless you can
the
point it out, we're going to have a problem.
Obviously, I see that, and I regret that deeply. But the Inspector Grimm report, which was the evidence we provided, clearly set out that EcoHealth and defendant Peter Daszak were involved in the creation and distribution and release of the COVID-19 virus.
All right, you'll have time on rebuttal. You may proceed.
Good afternoon, Your Honors, and if it may please the court, I'm Juan Olivo, and I'm here on behalf of the respondents. I want to touch on what Your Honor just brought up with respect to strict liability, because it's the only claim that may have oxygen to it. The court's aware of the factors in Dudakis versus Hempstead, which outlined the analysis for whether or not there is strict liability. And what I want to jump into is, in her complaint, the plaintiffs allege throughout that EcoHealth Alliance and Dr. Daszak negligently carried out this conspiracy, if you will, just borrowing words from the complaint. At the same time, they're trying to ask the court to sustain a strict liability claim. So in one hand, they're saying EcoHealth Alliance and Dr. Daszak acted negligently, but at the same time, they're telling you there's a claim that's viable that shouldn't be struck down, because it doesn't matter how much care they would have exercised. It doesn't matter if they were negligent.
So let me ask you, was Dr. Daszak in Wuhan?
Your Honor, I can't answer the question of whether or not Dr. Daszak was in Wuhan on December 31st, 2019, but he's been to China before.
Okay.
But the allegation that
Question,
he's...
right, that
the
he is the
allegation that
one.
he's the-
Counsel, my colleague is talking,
Sorry.
and when the court is talking, you shouldn't be.
I'm just trying to figure out if the allegation is that he actually did the virus manipulation,
Your Honor, I think that's what the allegation is.
okay? Because I didn't see it in the complaint.
Right. I think, neither did I. It's very difficult to understand what the actual allegations were. And as a matter of fact, my adversary said that we casted the allegations of the complaint as one of regarding funding. That was actually Judge Rashan in the Southern District of New York in a case called EcoHealth versus EcoHealth Alliance, who picked up on the fact that this is the best you could take the allegations of the complaint and the best cause of action that you could set forth is a funding cause of action.
All right, well, let's take it as a funding. Is the manipulation of viruses in a foreign country over which the United States would have little to no control over, with the purpose of trying to create stronger strains of virus an abnormally dangerous activity?
I would say the answer to that question is no, Your Honor. But that's not necessarily the question.
Why is it not?
In this regard, it's because the government authorized this research to take place. The government issued a grant.
So it's okay to do abnormally dangerous things so long as the government says it's okay?
Well, I wouldn't say that, Your Honor. What I will say is there would need to be something to be resolved.
Be very careful how you answer, okay? Because like you, we're lawyers too, right? So we're listening to every word you say, okay? And so if this was too dangerous, it's not abnormally dangerous because the government funded it, then you're saying that all case law should say that if government funds research, that ends the inquiry?
No, Your Honor, and thank you for stopping me from that. Let me clarify. That does not end the inquiry. What I should say is that the government wouldn't fund this research. The NIH wouldn't fund this research if they thought it posed a grave risk, not just to these plaintiffs, but to
The
everyone.
government is never wrong.
I'm not here to say that, Your Honor.
Let me
Say that today. Okay.
They did decide in April 2020 to discontinue the funding,
I should say, Your Honor,
or cease the funding, suspend the funding, whatever the appropriate
the
word is.
proposal at issue, Your Honor, ended in September of 2019. It was a 5-year research grant that commenced in 2014. It ended in 2019.
Where in, I saw that statement, but where in the record is there proof that it ended in 2019? Could you tell me where in the record I could find that documentary evidence that tells me, that puts the nail in that particular date, that that's the date it ended?
I cannot, Your Honor.
Okay, because I couldn't either.
Yeah.
So that's a problem, because you make this assertion, but I see nothing in the record to support that statement.
What I will say, Your Honor, this is
May
what
I
you were-
ask you a different question? Are you arguing, for example, that research into viruses so that we can create vaccines shouldn't be considered abnormally dangerous activity, right?
No, Your Honor, that's not exactly what I'm arguing.
What are you arguing then? It should be considered abnormally dangerous? Should we not
That
be
was a
doing it?
softball
I
question,
know,
by the way.
I was trying to help you out there and it didn't go very far.
I'll answer the question. What I'm arguing, Your Honor, is if the NIH issues an award to a nonprofit research institution to conduct research that provides for subcontracting the research outside of the country, that should not be subject to strict liability.
Okay.
Is that because there are gain-of-function research, while it may entail some dangers, also has significant societal benefits?
That is correct, Your Honor.
Okay, thank you.
So, if I may, I'd like to answer the questions as quickly as I can. There is no time in the history of the gain-of-function research, such as December 2019, where we alleged the activity occurred. It was over a period of years, beginning in December through the release of the virus. Secondly, Your Honor, with respect to gain of function, the prime contractors, prime contracts that were awarded to EcoHealth all specifically contained provisions that they were responsible for their subcontractor research. Third, Your Honor, Congress has already determined that the type of gain of function research that went on at Wuhan, which as prime contractors, EcoHealth was 100% responsible.
Is this the report that happened after this case was decided?
No, it's the statute that was cited in our briefs that if you,
Was it done after the case was decided, is my question. There was a report here that,
yes, but you've already determined not to provide judicial notice to that. I'm not talking about that.
Okay.
I'm very careful about that.
okay, I was
clear on
just
your-
making sure. Go ahead.
No, but prior to that, they're contracts, they're prime contracts. Any prime contractor, any federal prime contractor is responsible 100% for the activities of their subcontractors, whether they're in the United States or they're in China. And finally, the point I'd like to make, distinguishing between strict liability and negligence. I want to be very clear. Congress has already indicated that the type of activity that went on in Wuhan, manipulating viruses, is strict liability. It completely fits under the factors of Dundalakis that my adversary here mentioned, okay? Well, our position is we fit 100% under Dundalakis and Spano. With respect to negligence,
You're out of time. I'm going to give you another 30 seconds, and then that's it.
and that's all I need.
All
Thank you.
right.
With respect to the negligence was a separate cause of action that involved the release of the virus and the cover-up of the virus. And I respectfully submit
And you're claiming that's EcoHealth?
it was EcoHealth, and they covered it up. They engaged in a
Okay.
conspiracy.
EcoHealth was in charge of all of the records that were under the control of the Wuhan lab and the Chinese government. That's your argument.
Not at all. EcoHealth was responsible for the records.
I heard that argument already, but I'm talking about post-outbreak when we all know that we were getting no information from the Chinese government. So if our government couldn't get information from the Chinese government, we expected that EcoHealth could? That's your argument?
EcoHealth was the one generating the records.
All right, thank you.
Thank you very much. I appreciate your time.
979 Second Avenue versus Chow. Oh, this is gonna be.
First at all, I need a translation. My English doesn't very good. I'm 75 years old, senior, and can you have the translation?
We don't have a translator in this building. If you needed a translator, you had to ask for that, and your attorney would have known that one would have had to be requested ahead of time. So I'm afraid we have no translator.
So-
But we can accept your papers that your lawyer put in for you and consider those on your behalf.
Okay, I speak slowly. I hope you can understand.
Okay, speak right into the mic so we can hear you.
Can you hear me?
Yes, just talk loudly and as close to the mic as possible. Okay.
Your Honor, good afternoon. First at all, this is a very sad story because I not the person of the tenant. And also, I go to 3 women government department, ask, they give me one form. He say, this U.S. District Court held to Southern District already held, its code is 22-1005, already voided the personal guarantee because it's government shutdown, not I shutdown. So this guy, because before it's store, big gas explosion, cannot open Chinese restaurant. But that time he already breached 9B, the contract. He taken over 2 million I bring from Hong Kong, the money. He take from me. He said, I will sell the building to the Hong Kong group. Hong Kong group is very rich investor. So I trust him, have bank record, over 2 million he took already. Then basically, in the finally, he still don't to put it in the market. I say, you in the contract have rights of first reversal. Why you breach contract all the time? Breach 9B, take my money, over 2 million US dollar. Then he don't give me back. He say, so what? You go back to China. Looks like I'm very stupid Chinese lady, he think. But I'm business. I'm not a stupid. I'm honor. You know, most Chinese very honor by heart. Yes. Then he don't want to say to me, okay, never mind. Then later on, COVID coming, government shut down, everybody stay home. And it's not I shut down. So he say, so after that, he sold the company. Lucky, my name not in the contract because some lawyer advice. He said, you come to America, be very careful. Never put your name in the contract. For the company, if a company, how much is how much? Wawin Group, W-A-H-W-I-N, Wawin Group is China, the rich people, they investor. Because I'm in America, I have an American passport, so on behalf of them. He think I have money, I don't. I just help bring the investor come to America. Then he sold the Wawin Group. Then the lawyer say, if that he sold Wawin Group, nothing to do with you. You are an individual. Then afterwards, he know Wawin Group, not many things. So he tried to.
Okay, Ms. Chow, you've run out of time. I'm going to give you more time after I let the other side speak, okay?
Very simple. Sorry.
You have a seat, and I will let you talk again in a few minutes, okay? Have a seat, and he will talk, and then I will let you talk again, okay? All right.
I believe this belongs to you. Just gonna move this out of my way. Good afternoon, Your Honors. May it please the court, Daniel Levinas on behalf of the respondent.
I need you to use that mic, too.
Second Avenue LLC.
Okay.
Your Honors, in essence, this appeal marks the appellant's 4th time attempting to re-argue identical allegations of fraud, forgery, and questioning the validity of the authenticity of a guarantee, a personal guarantee of lease that she signed. And it runs the gamut from 2 prior underlying actions and then also an appeal before this court. That's 4 separate times, 6 times if you include underlying motions to renew and re-argue in the underlying cases. The first time was in December of 2022.
We get the point.
Yes. So
I will say that listening to the appellant right now raise issues in connection to the guarantee law. There was a footnote in my moving brief that stated, or my opposition brief rather, that stated that there was no guarantee law covered protection period rents that were sought on this guarantee that ran from March 2020 through June 30th of 2021. Everything in the underlying action that we sought, the rents that we sought from the guarantor, began to run July 1st, 2021 and on.
After that ran.
After that period, that's exactly right. I would mention also that the guarantee law arguments were never put before on the record to Justice Frank in the underlying action. I think the appellant is conflating issues that she raised in several other actions that have been pending in the Supreme Court. So with that, I'll reserve the rest of my time for reply.
You have no more rebuttal, but thank you.
Okay.
Okay.
If there's no questions, then I'll.
Thank you. You may speak, yes.
Thank you so much. He always talking about guarantee law. Have 2 points. 1 point, I did ask.
I just want to say, you asked for an interpreter, but your English is very, very good.
Thank you.
Okay, go ahead.
I speak slowly. I afraid don't understand legal words.
That's okay. We understand you. That's all that matters.
Okay, thank you, Your Honor. He talking about guarantee law, have one decision from Judge Frank already told him make a decision. Here there is no guarantee law because government already voided the guarantee law in the 221005. It's Judge Frank give him already. Then he told my lawyer, he said we settle. He know no guarantee law, I nothing to do with them because it's company Huawei, it's not me. I never guarantee, number one. Number two, novation contract law is to say, if your first contract is March 1st, 2011, signed, I very clearly, I said, China Group, they don't want any guarantee. So this lease, no guarantee. If you have a guarantee, I don't sign. So that is clear. I think you have record. March 1st, 2011. Sign is no any guarantee. Then afterwards, the gas explosion in the September 22, 2011. That time cannot do any business, cannot have gas until today. You can go to check. Government, New York City, don't let he put the gas. It's explosion, maybe neighbor, all the building were coming down. So no gas at all. So after that happened, he wanted me go to there. He said, sign. I reduce the rent, become half. So, okay, I signed.
I thank you. We are out of time, but I have your papers from your lawyer, and we will look at everything carefully.
Thank you.
Okay?
I just never gave guarantee because in the contract, don't have guarantee.
Thank you.
Government also avoided the guarantee.
Thank you so much.
Thank
you
you.
have a good day.
Thank you.
Thank you.
Thank you, Your Honor.
Moore versus Scanza, USA. You may proceed, counsel.
Thank you, Your Honor. Excuse me. Yes, Jason Levine on behalf of the plaintiff appellant. We submit that the plaintiff's deposition testimony met out a prima facie case of entitlement to summary judgment on the Labor Law 240 claim.
But doesn't the affidavits that were submitted by the defendants raise an issue of fact that we can't deal with on this kind of, at this time on a summary judgment motion?
I would submit that they don't. Those two Neiman affidavits, which are essentially identical, we submit don't raise an issue of fact.
Wait a minute. Your client says, I was told, I was directed to go and do this work because it was a rush situation. And his boss says, I didn't tell him to go do anything. How is that not a issue of fact?
Oh, no, because the Neiman denies the conversation took place. But
Right.
I would submit it's of no consequence, though.
No, wait, stop. One says a conversation happened saying, I'm directing you to do work, the injury-producing work. And then the other guy says that conversation didn't take place. Again, I'm going to ask, how is that not an issue of fact?
I would submit, Your Honor, that perhaps on its face it may look that way, but under the circumstances of what took place, no, Your Honor, because look
Go
at
ahead.
the scope here. The plaintiff was the sole HVAC representative on site that day. There were no other HVAC workers there. He was faced with a situation, whether or not they had this conversation or not, I would submit is of no consequence in view of the plaintiff's own testimony, that he was faced with a situation that there was a malfunctioning HVAC unit. And he was the only representative on site. There was no one else there to do the work. He has experience as an HVAC technician. So we would submit it's foreseeable under those circumstances, regardless of whether or not they had this conversation. I think if we take that completely out of the equation,
But we can't take that out of the equation. Your client put that in the equation. And we have somebody who says that didn't happen. That equals an issue of fact.
I respectfully disagree with Your Honor.
I'm
Just
sure
in view of
I
the
see that you do.
in view of the circumstances of what I just relayed, is that he was faced with a situation. It was foreseeable that someone in that situation, in his position as an assistant project manager, would have to go up on a ladder and make this repair to the malfunctioning unit.
I really don't see how you think that fact pattern you've just described is better than the one you have. I really don't understand how you're making this argument, because your guy, this is not what he does at the site.
Well,
This is not what he does at the site.
Well, you know what, we'll give him another fact.
The fact that he may have experience that would have given him particular knowledge to deal with this problem, okay, but that wasn't his job. And so by making the argument you're making, you're leaning into their argument, which was this wasn't his job.
I'm not saying that at all, Your Honor. I would submit
I'm
respectfully.
saying that's his argument.
I understand that's
and
what
you're
they're saying.
feeding right into it with yours.
Well, no, because the situation here is that, okay, maybe he didn't expect that day, and the court picked up on the fact that, okay, he's wearing a dress shirt and dress shoes, so obviously.
Well, let's go to some other facts, because what do you think about this? Because there was also testimony that it was physically impossible for your client to lean into the access panel as he claimed he did.
I would say, Your Honor, that testimony merely would be significant if there was an issue, if he was misusing the ladder in some particular way. I would say there's no dispute here that the ladder slipped out from under him while he was working from an elevated height.
Yeah, but there's a dispute about how it even happened, because you also have the evidence that they received a call regarding the fan unit that's totally unrelated to the air conditioning units in the mechanical room. So what about that?
Well, I understand that. That's a separate issue, but
Yeah,
here,
that's another one.
I would submit that regardless.
And counsel, how do you, counsel, may I interrupt you for 1 second? Let me just, and how do you deal with the fact that the testimony was that this whole area was turned over to NYU, and there would be no reason for your guy to do anything anyway? That floor had been turned over to NYU, and if there was something going on with the air, it was NYU's issue, not your guy's issue.
Well, I
So
would
all
submit,
this is what I'm saying. It's like this, plus the fact that his boss said he never told him to do it, plus his evidence that what he says is the issue was not the issue that the documents show, plus the pictures show that it's hard to tell one way or another whether he could have gotten in there. You know what all this
may
combined.
I finish, though, even though
I'm going to give you 30 seconds to answer that question, and then you'll have time on
with
rebuttal.
respect to whether or not the work was completed on that floor, this was still an ongoing project. The work was not done. And whether or not the actual work in that mechanical room was finished, which it was, we're bound by that certificate of compliance. Nevertheless, as the subcontractor for the HVAC on this project, they were still bound under their subcontract to undertake.
And it was leaking on that day, right?
Right.
Okay.
So, okay,
We'll
I'll
hear it
reserve
from
my
you later.
time for rebuttal. Thank you.
Pollock from Fabiani, Cohen and Hall on behalf of the defendants. One thing to follow up, you said you were not sure about the physical impossibility. The opening that he claims he put his 6-foot body into was about the size of this pad.
I'm sorry. The photograph shows that as being bigger, and your photograph has pipes blocking it. So that convinces me of nothing.
Plaintiff said it was 12 inches by 12 inches.
He didn't say he put his entire body through
He
it?
said he put his up through his chest with his arms outstretched
Right,
into
because
that
he
through
needs
the
to
opening.
get the screwdriver in, right.
So that was,
It's called an access panel, right?
yes.
Right. So what does an access panel provide you? Access, right? So obviously, this hole was useful for something.
It was useful to access the interior with whatever equipment would be needed to reach in to get that far in. A human body could not have fit into that space.
All right.
Again,
So I agree, that's an issue of fact. What else?
The other issue is, because your honors mentioned the issues of fact. One which is, again, since the area was turned over already, even the plaintiff said there was no construction taking place on the second floor at the time of the accident. Even if the accident did happen, which we don't concede even happened, the plaintiff argued that, and there's no doubt that the ladder slipped. We're not conceding the accident happened. It was unwitnessed, and there's credibility issues, so we don't concede it happened. But since the construction was over on that floor, even if you believe there was an accident, at best it was routine maintenance because all
What case law says that?
says what?
What case law says that if there's still ongoing construction within a project, the fact that a floor is done doesn't mean that if you have to go back to that floor to deal with something, that now equals routine maintenance. I would say if you just put in a system and it's already leaking, you obviously didn't put in that system right. So go and fix it and do it right. That to me is not maintenance.
It wasn't leaking. The plaintiff claims, again, the conversation never happened.
According to the plaintiff, he was called and told there was a leak, go fix it. So that's an issue of fact.
I agree with you. There's issues of fact.
Okay.
Lower court should be affirmed. There's issues of fact, of credibility, of what happened, and that's why the lower court should be affirmed. Thank you.
Thank you.
Just very briefly, Your Honor, with respect to the status of the work on the second floor, construction was not completed on that second floor. Construction in the particular mechanical room where the HVAC units were done. But as the plaintiff testified, he retrieved a ladder from workers, albeit not HVAC workers, who were actually working on the second floor.
So what did the certificate of substantial compliance that Nelson issued to Skanska for the work on the second floor, what did that mean? What significance did that certificate have in the context of whether the work was done or not completely done?
I think that only pertains to the actual HVAC machinery that was in that mechanical room where the accident happened. This was a 10-floor build-out or fit-out where work was ongoing, including still on the second floor, albeit perhaps not by the certificate of completion indicated that they had substantially finished their work in that particular room.
And was the plaintiff working on the second floor on that date where the problem occurred?
That's where the incident took place, yes, Your Honor, in that mechanical room where the HVAC units were located.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you.
People v. Kevin Williams.
Good afternoon, Your Honors. Nick Justice for the Legal Aid Society on behalf of Mr. Williams. I'd like to focus on this stop and frisk today. Mr. Williams' Fourth Amendment rights were violated when 4 police officers approached him in a V-shaped fashion, surrounded him, and ordered him to keep his hands up for doing nothing more than urinating in public.
Well, urinating in public is not something that we approve of, right? And police officers certainly have a right to approach someone who is violating the law and urinating in public, correct?
They have a right to approach.
Okay,
but they,
and we have a video of that approach, don't we?
yes,
Okay, you can proceed.
Yes,
Because we
and-
saw the video.
yes, Your Honor.
Go ahead.
And although the police have a right to approach, they must do so in a way that's commiserate with what's causing the approach in the first place. Here, when the police officers forcibly seized Mr. Williams, very close to the degree to a formal arrest, if not a formal arrest, at least a forcible seizure.
Does the law say that an officer has a right under the law to either issue a desk appearance ticket for a violation or arrest an individual?
Our Court of Appeals has held that there are certain violations that, even when committed in the officer's presence as a matter of the state constitution, cannot be effectuated with a formal arrest. This court does not need to this court does
Really?
not-
Okay, go ahead.
Yes, People v. Coleman and People v. Marsh, and this court does not need to answer the question of whether public urination is such an offense in and of itself, because the court found explicitly in its decision that the act of public urination provides only a common law right to inquire, and this court is bound by that.
She also found that while it provided a right to inquire, she also found that the officers had the right to either issue a DAT or arrest. She also made that finding. That was part of her written decision.
I disagree with that, Your Honor. When the court in its decision referenced the right to arrest, it did so only after finding that Mr. Williams' knife, when the officers found the knife on his person after ordering to keep his hands up, that elevated the encounter, and that additional presence of danger gave
So
the...
she didn't say what I just told you.
No, I think the
Really?
opinion read...
Okay. Go ahead.
Well, Your Honor, if the court is convinced that the initial seizure was lawful, that still does not validate the subsequent frisk. By the time Mr. Williams was seized, they had, under People v. Miranda, they had...
I believe as they approached, they observed what appeared to be a knife, and the officer testified he could not tell what kind of knife it was. Based on the case law I'm familiar with, an officer is certainly entitled to physically apprehend someone who has what they perceive to be a weapon.
I mean, I thought that the judge, well, actually, I have her decision, so I know that the judge said in her decisions, as the officers approached the person, they approached him because they saw him urinating in public. The individual raised his hands, which is what I saw in the video, at which point the officers observed a silver pocket knife clipped to the right pants pocket of the male individual. So before they even got to him, they saw this knife.
Well, no, Your Honor. When his hands went
So
up...
she was wrong, that's not what happened.
Well, when his hands went up, that was in request to an order. But as to the legality of the frisk, even if when the court saw the knife, the officer was clear.
When the officers saw the knife.
When the officer saw the knife,
Yeah.
he was clear that he believed it was a lawfully owned pocket knife, or could not tell the difference between...
He didn't say he thought it was a lawful. He said, I could not tell. Counsel, please.
As far as he could tell, it was nothing more than a pocket
He
knife.
could not tell.
That's all one can observe.
Right, and so, and again, a police officer should approach someone who might have a knife.
Under People v. Miranda, they have the right to seize the knife. But at this point, as far as they knew, Mr. Williams was doing nothing but urinating in public. Once they had the knife, there was no reason to believe he had another weapon, no reason to believe he was...
No, wait. I thought when they got the knife, he saw the gun in the pocket.
No, that's incorrect. They took the knife, and once they had the knife...
Yes, because he reached for the knife. And so he reached for the knife. So let's stop there. Because from my recollection, the trial judge said that certainly a limited search for protection, for safety.
No, Your Honor.
No?
The court did not mention the reach for the knife, because when Mr. Williams was going to hand...
Video certainly shows that.
The video shows him... May I
ahead.
answer?
Absolutely.
The video shows him reaching for the knife, but it was in compliance with the officer who directed him to his knife. I would encourage the court to look at the video again. Mr. Williams is standing with his hands up. He's not making any sudden movements, and when the officer directs him to the knife that he sees on his waist, he brings his hand slowly down, and his hand never even reaches the knife because the officer says stop, and he puts it right back above his head. It wasn't until just after that, that the frisk happened, not with any observation of a gun.
So you're saying at that point they weren't entitled to frisk?
They absolutely were not entitled to frisk at that point.
All right, I'll hear you later.
Good afternoon, excuse me. Good afternoon, may it please the court. Paul Anderson for the people. The officer's observation of the public urination did not give him only the common law right to inquire. And think how that would play out. If an officer is giving a ticket or a summons and asks what's your name and the person walks away, the officer can detain to give that summons. And in the decision itself, the judge did not say only a common law right to inquire. And as to answer Your Honor's question, While it is true that DeBoer Level 3 inquiry, which permits an officer to forcibly stop and detain an individual, requires reasonable suspicion for a stop and search, it does not negate an officer's discretion to determine whether to arrest an individual for an offense for which a summons can also be issued. So that's page 6.
I know I read that. Thank
Just
you.
clearing that up. And then, yes. And
So let me just ask you, and it's your position, obviously, that the frisk that got the knife was a minimal frisk, right? They didn't ask much more. They didn't do much more than a pat down, right?
Yes, Your Honor.
And that's what I saw on the video.
Yes, that's what the court found on page 6 in the bottom, that once the knife was displayed, the officer testified that he felt the bulge, and then once he felt the bulge, it was L-shaped and then escalated. He could see inside of it. All of that is reasonable, and that is what you'd expect. We shouldn't have to wait for the glint of steel, as the Court of Appeals has said. And so, if Your Honors have no questions, I ask that you affirm. Thank you.
Thank you. You may proceed.
I'd just like to address some of the court's questions regarding the legality of the frisk, and I want to make it very clear what the officer's knowledge was at the time they engaged in the frisk. They had the right to approach Mr. Williams, of course, to issue the summons, and when they saw he had a knife that they did not know whether it was legal or not, they were entitled to seize it for their protection. But at that point, they had no reason to believe that he was breaking any law other than urinating in public.
You're saying he had I'm sorry. At the time they see a knife on him, they don't have a right to do a little pat down to make sure he doesn't have any other weapons on him?
No, if they don't believe the knife is unlawful.
No, no one testified to that. The officer testified he didn't know what kind of knife it was.
That's exactly right. So he has because he has no reason to believe Mr. Williams is breaking any law at that point.
So it's your position that unless he knows 100% that that is a 15-inch knife, he can't do he or she can't do a pat down?
Well, he can seize the knife, and of course, if it's legal at that point, they can continue with a pat down.
But before they even did that, again, the judge found that after observing the knife, that's observing, not the officer, one of the officers walked behind the person and observed a large bulge protruding from the right coat pocket. So the testimony seems to support that before they even tried to get the knife, when they walked behind him to attempt to do that, they already saw a bulge. That wasn't what happened? I mean, was she wrong in all that?
No, Your Honor, I would disagree with your recollection of the record there. I believe.
Well,
recollection.
I'm actually reading from her
Then
decision.
I disagree. I apologize. I disagree with that portion of the decision. The record is clear that the recovery of the knife came after he frisked and felt the L-shaped bulge, and the officer believed that he could frisk because he observed the knife. Our position is, under Court of Appeals precedent, People v. Miranda, they did not have a right to do anything more than seize the knife.
Thank you. Kirby Forensic Psychiatric versus Myron M. You may proceed.
Good afternoon, and may it please the court. My name is Leonard Simmons with Mental Hygiene Legal Service, and I represent appellant Myron M. in this appeal. Myron M. was ordered retained to a forensic psychiatric center for 2 years after a hearing in which he legally could not prevail, violating his right to a fundamentally fair trial in which he was deprived of access to the basic tools of an adequate defense. Under this court's precedent, a 330-20 defendant...
Wait. Why could he not prevail?
So under this court's 330-20 precedent, long-standing, a defendant cannot rebut a hospital's expert testimony finding a dangerous mental disorder without contrary expert testimony. So as soon as he moved for an independent expert and that was denied, he lost any opportunity to present any relevant evidence.
The law permits an appellant to hire their own psychiatric expert, and so he wasn't denied. In that sense, in that he could have obtained an expert in some other form and offered that to the court. That wasn't offered and denied by the court, correct?
Your Honor, Myron M. is indigent.
That was not offered and denied by the court, correct?
Hiring his own expert?
Yes.
No, that was not denied by the court.
Okay.
Myron M. is indigent and cannot afford his own
Do you have
expert.
counsel?
Yes, we represented, not myself, but we represented him below.
Okay, so I understand your point, and it's certainly not a frivolous one that the indigent respondent in this situation could benefit from an additional independent expert, but wouldn't the attorney be able to cross-examine the testifying physician, perhaps very persuasively, perhaps undermine whatever the evidentiary foundation was for the expert's opinion?
Your Honor, this court has said that that is not enough. So starting with Jamie.
Was there an application? So, look, we are familiar with the case law. And we are very familiar with the statutory construct that guides this area of law. Why should this court substitute the wisdom of the legislature and impose requirements that are not embodied in the statutory text?
Because it's required by the Due Process Clause. Because Myron M., in a proceeding in which his liberty was at stake, was entitled to the basic tools of a defense.
What in particular was contested here, other than making an application for my own expert? What did you challenge of the findings of the experts that came before the court? Because the court, under this statute, was certainly entitled to require another expert if they thought that the expert testimony they received was inadequate. So as my colleague suggested, had the defense cross-examined and done damage to the evidence, the credibility, the testimony of the experts of the state, perhaps that application might have been granted. So tell me, what was it about the evidence that was offered in support of keeping your client in the facility? What was it that was contested that should have required the judge to grant your application, which I think is really the only way that you can prevail here?
Well, Your Honor, we contest two things, but I will say that as a matter of constitutional law, we believe that he was entitled to an independent appointment even before the trial started, because otherwise there was no way for him to meaningfully participate in the trial or put forward any defense at all. Under this court's precedent, cross-examination has never been found to be sufficient without an expert.
So the trial judge couldn't have found the cross-examination of the doctor persuasive and found in your client's favor?
This court has never upheld such a finding before. It has happened before.
So why do we bother engaging in this fiction then? The doctor should just testify and the court will rubber stamp it and that'll be that.
That's our concern, Your Honor. Is not that the court is rubber stamping it, but that the court doesn't have a choice, because the last 4 times this court has addressed this issue where something like that happens, whether it's the person's own testimony that makes the court want to transfer them or whether it's cross-examination, the last 4 times this has happened, this court has reversed, citing the unrebutted expert testimony, which...
I was saying, counsel, I mean, isn't this really something for the legislature to address? I mean, the way this statute, it's a pretty long statute, this 33020, goes on, has a lot of different subsections. And I hear your argument. I think we all hear your argument. But the way it's, I mean, how do we deal with the statute as it's presented to us now?
I think the same way the Supreme Court did in Ake v. Oklahoma. This cannot be fully discretionary for indigent defendants because courts can't decide who gets a fundamentally fair trial and who doesn't. All of our clients are entitled, all defendants, especially when their liberty is at stake, are entitled to a fundamentally fair trial. And under Ake, that's what was required. The Supreme Court...
But again, see, I keep on asking you, how did you challenge in your request for your own expert? How did you challenge the basis of the state's expert so that the court could say, you know, they've got a point. I should hear another side of this. What did you challenge other than we disagree with the state? I mean, it can't just be that, because, counsel, then we're talking about the potential cost of this statewide would eat up into the resources that I would hope would go into actual treatment so that these clients can get better and actually be reintegrated into society. So, well, you have time to kind of think about that, because that's one of the things I'm concerned about.
Justice
right?
Manzanet Daniels, may I?
On rebuttal, please.
No worries.
Okay. I'll give him extra time so you can get your question in.
Good afternoon, Your Honors. Andrea Trento from the Office of the Attorney General for the hospital respondent. I'm just going to hit a couple points that were raised in Your Honor's questions of my colleague here. In terms of the process that was available to this individual, there were numerous avenues that this individual had to rebut the state's evidence that was put on, or the hospital's evidence that was put on at the hearing. Setting aside
how what are the multi avenues
Yes, Your
that are going to escape the case law that your adversary cited, which said there was no rebuttal expert?
Sure. The avenues
Tell me.
included, aside from the retention of an expert, either through the individual's own resources, those of his
Well,
family.
he didn't have any, so
or
really.
MHLS itself.
Can I ask you something? What if all the records show that he, right? Could he put in his own records? Shouldn't if that is his own psychiatric records, could obviously rebut if the records showed, because not only one psychiatrist, and probably not the testifying psychiatrist, deals with him the whole time he's at Kirby, right?
Your
So
Honor.
there are lots of people writing notes and records, and those could all be put in, right? And those themselves, which are competent evidence, could rebut the testimony of one psychiatrist put on by the state, right?
Your Honor is touching on my very next point, which was the fact that Dr. Lamb wasn't the only professional provider that examined the witness. There were 5 individuals who signed the application for retention that was submitted for this particular application. In addition, there were other providers over the 5 or so years, the 4 years that this individual was at Kirby. Numerous providers examined him, medical providers, psychiatric providers, psychological providers. One, in fact, was the medical doctor who examined this individual when he was admitted at Kirby, gave an opinion about, or in the medical records, referenced the fact that this individual had this traumatic brain injury that could have impaired his judgment with respect to the crimes at issue. Counsel questioned Dr. Lamb about this particular provider, Dr. Siegel's findings on cross-examination.
Would a respondent in Myron's position have the right to subpoena
Absolutely.
any of those physicians reflected in the medical
Dr.
record?
Siegel could have been subpoenaed to appear at the hearing and give testimony about the examination that Dr. Siegel.
But is Dr. Siegel a TBI expert?
Dr. Siegel is a medical doctor. I believe he was a psychiatrist.
Is he a traumatic brain injury expert?
I don't know the answer to that, Your Honor, but Dr. Siegel could have provided testimony about his examination that, at least based on the cross-examination that counsel performed at the hearing below, he interpreted as favorable to his client. But no effort was made to do that. That was an avenue that was not pursued by the appellant. There was ample process available to the appellant.
Let me ask this question. I don't have to ask him. Below, was there any argument or showing that the evidence that came in, somehow it was deficient and more information was needed for the judge to make their determination?
No, Your Honor. Dr. Lamb covered all of the bases articulated by this court in Belfie for determining whether retention is appropriate. He addressed this issue about the traumatic brain injury, noted that it was Dr. Siegel had made that determination, but Dr. Lamb, in his opinion, said he believed that the delusions that the appellant was experiencing were the cause of his mental illness. And in any event, even if this traumatic brain injury had some impact on the appellant's condition, the James Q case coming out of the Third Department, in James Q, the Third Department reversed the trial court's finding in that case and held that the combination of a bipolar disorder and traumatic brain injury could combine to create or give rise to a dangerous mental disorder requiring retention in a secure facility. It's not clear what would have happened.
So that decision was made without expert evidence? There was no TBI expert who testified about that, and that was the determination?
I can't say, Your Honor, what I don't believe that the appellate division's opinion referred to a TBI expert.
What about the Matthews factors? I think we would all agree factor one militates strongly in favor of the respondent here.
Can I take issue with that, Your Honor?
Go right ahead.
I'm not sure. It certainly is an interest that the appellant has, a liberty interest, but it is not unequivocal in this case. And the reason is, there are two reasons. One, he is not at liberty right now. He is confined in a secure facility. And the matter of ed case that the appellant cites does stand for the proposition that that liberty interest is a little bit different when, as in matter of ed, the individual had lived for 2 years without an order of conditions and was being asked to then be subjected to an order of conditions. The court found, well, this is actually an infringement on liberty that wouldn't have been the case if he was being asked to continue an order of conditions. Here, the appellant is being required under the order to continue a retention. And so it's a little bit, it's not quite the same as in matter of ed.
No, but it's still a very significant restraint on his freedom.
The second point is the appellant's interest is not unequivocal with regard to liberty. The appellant's overriding interest is to be treated properly. And so certainly he has an interest in liberty consistent with that, but an erroneous determination that he should go to a non-secure facility could result in harm to him and harm to others that ultimately redounds against his interests. And so I'm happy to continue to address the Matthews factors, but I see my time is up.
Thank you.
Good afternoon, Your Honors. Michael Balch for the District Attorney's Office. Just a couple of points I'd like to address from appellant's reply papers. First of all, with respect to this TBI issue, I'd like to point out that the TBI issue was not raised in connection with either appellant's written motion to the court asking for appointment of an expert, or at the end of the hearing.
So we should ignore that after this man had his skull fractured in a car accident, not even a year later, he begins acting out violently. We should ignore that.
Not ignore it, Your Honor. It was discussed during the testimony at the hearing, and as my colleague...
It's part of his file, so it's part of the facts.
Yes, Your Honor, and Dr.
Okay.
Lamb addressed it, saying that it was more of a psychotic nature, his delusion.
And I saw nothing in these papers that at all satisfied me with respect to the interplay between the TBI and his psychotic features. Okay? There is an impact on it. And to pretend that there isn't is not acceptable.
Understood, Your Honor. One other issue from the reply papers that I'd like to clarify. There was some discussion in the briefs back and forth about whether appellant was seeking an independent expert. It's been our position that the record is clear that they were seeking a partisan expert to advocate directly for.
Every side should have one, right?
Well, they're proposing.
Counsel, come on, okay? The state doesn't put on an expert that doesn't agree with the state, right? So.
Yes, Your Honor. I just want to point out that their proposed order specifically stated that they would request the particular psychiatrist, not that the court would make an independent appointment. Court has no questions. I'll rest on our brief. Thank you.
All right. You'll have time, 2 minutes?
Thank you, Your Honor.
I'm gonna give you a little extra.
No, I posed it to counsel.
Okay, all right, go ahead.
I'll start with your last question to me, Your Honor. So on pages 84 and 85 of the appendix, we have the trial counsel stating the reasons why an independent needed to be appointed. This is before the case actually started. And she cites two things. One,
So let me make this clear. You're not seeking an independent psychiatrist, right? You're not seeking the court to say, let me go out and get a psychiatrist, because if that psychiatrist agrees with the state's psychiatrist, you're not putting that psychiatrist on, right?
So if it was
You're only looking for someone who's going to support your client's desire to leave the secure facility. So Oh, you're telling me if the judge said, yeah, I'm going to hire this psychiatrist, and the psychiatrist comes into this with the same view as the state, that you would want that, you would put that on your case?
If it was an independent psychiatrist, I don't think that we would have a choice. We asked for a psychiatrist that we always referred to as an independent, and the trial court only ever refers to as an independent, to evaluate him and testify regardless of what their opinion was.
So in every case, we should have an outside psychiatrist hired, even if that psychiatrist is simply going to agree with the 5 psychiatrists that have testified? That's your due process argument?
Our due process argument is that when you have an indigent 33020 defendant who is contesting their retention, that is the only possible way they could put on a case.
So let me go back. Because we have said unrebutted evidence, have we ever said that you could not use records and other information? Have we ever said that directly? Because I haven't seen that.
So what the court has said is that we need psychiatric evidence and the opinions of mental health professionals.
So why couldn't that be in the form of records?
So that has never been sufficient before.
Well, have you ever, okay, so the fact that you haven't been able to command the evidence doesn't mean that you couldn't, right? It's just you haven't. And you could subpoena the psychiatrists who have treated him, who you would think testimony would be helpful, right?
So may I address both of those?
Sure, yeah.
So to start with the second one, with regard to Dr. Siegel, even if we could have subpoenaed Dr. Siegel had not evaluated Myron M. in at least 5 years. It's unclear whether his testimony would even be relevant, and he never evaluated him for dangerousness. He evaluated him for the criminal responsibility part of his plea. So it's unclear whether his testimony even would have been relevant, even if he would come and testify.
But I mean,
So wait a minute, you're saying his assessment was only as to his fitness to stand trial?
It was as to whether he lacked, it was with regard to the criminal responsibility plea, not the CPL 730 fitness.
Okay, all right.
May I, one more?
Yes?
I just have a more of a policy type question. If we agree with you on your due process argument, would the due process right that you're advocating for be limited to this context, or would it necessarily have to apply in the mental hygiene law 927 and 937 contexts, where there's involuntary?
So it would be limited to this context, Your Honor, and that's for a few reasons. One, because the Second Circuit Federal Circuit Court of Appeals has already said that this right does not apply in mental hygiene law Article 9 proceedings. There are also very different statutory schemes with different constitutional rights, different constitutional standards. We do not assert that an independent would be necessary, in large part because this court has upheld findings releasing defendants in mental hygiene law Article 9 cases, even when they have not had experts. This court has never, in the 45 years of the statute, upheld such a finding in a 33020 case. That's, I think, where the due process concern is coming from. It does appear to be impossible.
So I want to, before you sat down, I expressed concern about the implications of the relief you are seeking. And like my colleague, my concern is, if we were to agree with you, does that mean that now every single client who is inside a secure facility, who has been committed in lieu of going to jail, that every single one of them, where the state says you should be retained, now the state has to provide an expert?
If they are retained under CPL 33020 and they are indigent and they are contesting that retention, yes. It is necessary for them to be able to put on a defense. There is no other way.
Thank you.
Thank you.
People v. Kai Lee. You may proceed.
Good afternoon. The Legal Aid Society by Mimi Lee on behalf of the appellant Kylie. The prosecution has conceded here that the trial court erred in changing a condition of Mr. Lee's plea after he was sentenced without giving him the opportunity to withdraw his plea and without him being present. Unless your honors have any further questions, we would rely on our opening brief and ask that this court reverse Mr. Lee's conviction and remand to trial court for further proceedings.
Thank you.
Thank you.
Counsel?
Good afternoon, Your Honor. Stacey Nadell for the People. The People do concede that the trial court erred when resentencing defendant outside of his presence, and we agree with the defense that the case should be remanded for resentencing.
And whenever you can bring this to the attention of the judge before they complete, we would appreciate that.
Of course, Your Honor.
Okay. Have a great day, ladies. Soloway versus Sim Group.
Yes. Your Honor, Richard Wasserman of Wasserman, Grubin, and Rogers for the appellant. I will say that I've never been this low on the appellate calendar and spoken so early. Managing your docket very well.
Thank you.
So, counsel, can
Yes.
I ask you, if you don't mind, in looking at your briefs, wasn't your major argument that Judge Barak did not deal with the equitable estoppel argument? Really, wasn't that the basis of your
Yes, that
request
is
for it to
entirely correct. We actually included the briefs below as part of the record on appeal to demonstrate that point, that it was, briefed by both sides. And, Judge Barak, who I've been before a number of times and is a very wise judge, I think took a, I'll say with all due respect, simplistic view of the issue, and he said the obvious. My clients had not signed an arbitration agreement. He said that the underlying document, although it had a broad arbitration clause, simply did not apply because it said nothing about it being assignable. And our point is that he overlooked the equitable estoppel argument. He could have decided it was right. He could have decided it was wrong.
He just
but
didn't, deal with
He
it.
didn't address it at all. And what I'd like to, I'm going to assume from your questions that you're familiar with the equitable estoppel argument, and I won't
We are.
restate it. But what I'll discuss is, and I think we really clarify this point in our reply brief, that there are two different tests that one looks at. And the test that you apply depends on whether it is the non-signatory seeking to compel the signatory,
Right.
or the signatory doing the reverse.
Right.
And the essence of our argument is this falls in the former category, and what one looks to is not whether there's a direct or an indirect benefit, but you look to see whether the essence of the claim is that the plaintiff, in this case, the signatory party to the arbitration agreement, is asserting claims that really arise under the agreement in question.
Which is what this is all about.
Which is what this is all about. The plaintiff, the respondent, clearly was arguing, and we cite the paragraphs of the complaint on the relevant pages of the appeal, and in the record, it's pages 11 to 24 is the complaint, but paragraph 8 says, the defendants wholly departed and altered the spirit and terms of the old agreement. In paragraph 16, and I'm skipping some of them, upon information and belief under the old agreement, there were the following acceptable costs. In paragraph 17 of the complaint, it says that the defendants have and continue to impose new, unauthorized, and unreasonable financial fees. And in paragraph 19, it says, that there were fees and charges imposed which did not previously exist, which are not agreed to and not appropriate. That the essence of the claim is simply that the old terms of the agreement were not followed, and there's ample case law, and the Domke on arbitration, the leading treatise on arbitration, says that a party can't have it both ways. You can't insist on performance of the old agreement and then say you're not otherwise bound by the arbitration provision. And that's the essence of what I wanted to say and highlight the differences. So if you have any other questions, I'm happy to answer them.
I think we got it.
Okay, thank you.
Thank you. Oh, no. Pafanis versus A.O. Smithwater. Didn't come. Last but not least.
Thank you.
You may proceed when you're ready.
Thank you, Your Honor. Good afternoon. May it please the court. I'm Alex Green from the law firm CMBG3 on behalf of the appellant Donald Durham Company. Plaintiff Jennifer Pafanis alleges that decedent Anna Buzinski developed peritoneal mesothelioma from exposure to asbestos in a number of products, including Donald Durham's Rock Hard Water Putty. It's a product that you mix with water, it forms a paste, and you use it to fill in small holes in wood. Asbestos was not an ingredient in this product. It had 4 ingredients, one of which was talc. Plaintiff asserts that that talc was contaminated with asbestos, hence the exposure. But Mrs. Buzinski never personally used the putty, and there's no affirmative evidence that she was nearby when anyone else used it.
So, I mean, this is really a case dealing with specific causation, and that's what the problem is here. I mean, I know you're talking about a more general situation, but the defendant did submit some evidence here, but the specific causation is a little tough on this one. I mean, unfortunately, Anna passed away before she even had a chance to testify. And the only testimony we had about her exposure was through her ex-husband.
Yes.
And there was nothing else, nobody else that testified about the times that she had exposure to this Durham putty.
That's correct. Only one fact witness. It was her former husband.
Her former husband, right.
They were married for a very long time. So the entire time period here from the late 70s to about, I think it was about 2004, they were married for that whole duration. So he talked about a few instances of exposure at home when he was using the product at home. But he really wasn't sure he used it, how he used it. He wasn't sure that she was nearby. That's covered in the briefing. Then he talked about side jobs that he worked on the weekends. He did all sorts of work, and he remembered it in vivid detail. He said he was doing demolition all the time. He didn't talk about woodworking. He didn't talk about using wood filler. And we asked him directly, what jobs in your side work did you use Donald Durham putty? And he couldn't recall any. He said that he used it. He said he used it often. And we said, okay, how often? What do you mean by often? He said, I can't say. So we really have no quantification of his work. We haven't even gotten to her exposure yet. So there's a lot of speculation here as to how much dust could have possibly come home on his clothing from Durham putty that would have caused her exposure. It may have been none. But that's just one problem with the plaintiff's case, because when we get into the science, they have another problem. We have a toxicologist and certified industrial hygienist who performed an air sampling test in precisely the way that this court has approved of in McWilliams, that not only measures how much asbestos is released from a product, but how much is released into a person's breathing zone. He collected 59 unique samples, and every single one of them was found to be asbestos-free. This lets Donald Durham meet its initial burden quite easily. And we also have a pulmonologist who also offers the opinion, as does our industrial hygienist toxicologist, that this is insufficient to cause peritoneal mesothelioma, at least from Donald Durham's product, maybe not the other defendants. Plaintiff also has an air sampling test from Dr. Stephen Compton that was also done in a fashion that this court has approved of. Plaintiff's experts rely on that test, but there are some problems with it. First of all, it measures the exposure within the breathing zone of the person using the product or within 4 to 10 feet. She wasn't using the product, and we don't have testimony that she was within 4 to 10 feet. So these tests don't really apply to her. But an even bigger problem with the tests is that they only show a snapshot of how many fibers per cubic centimeter are released from their product at any given time. To form a lifetime dose, to estimate a cumulative lifetime dose of asbestos exposure from a product, you need the amount released at once, multiplied by the duration of that exposure, multiplied again by their frequency. We only have one of those 3 dimensions here from Compton's test, and even that applies to Mr. Buzinski, not Mrs. Buzinski. Furthermore, there seems to be a mathematical error in the calculation. It looks like the 0.36 figure, which applies to standing of the product or somebody within 7 to 10 feet of standing, was multiplied incorrectly. appears to us that it should have been 0.0351 fibers per cc, not 0.36, which is the number that plaintiff's experts relied on. I assume that Mr. Rodsky will address that. But there's multiple problems with this. The biggest one of which is that they just don't have the 3 factors necessary to form a cumulative dose. This court has ruled repeatedly that that dose is necessary, and it has ruled that that's necessary regardless of how a defendant meets its initial burden. In Tippin, just a few months ago, this court unanimously reversed denial of summary judgment because Johnson & Johnson put forward an epidemiological report from an epidemiologist, just one expert, no causation expert, no pulmonologist, up against 7 plaintiffs' experts. Summary judgment was granted. Here, Donald Durham has met its initial burden in 2 ways. First, it's shown that all of the exposure is purely speculative. And second, it has shown that there is no asbestos released from work with the product. This court has considered, since Nemeth, which clarified the causation standard, I believe 6 summary judgment denials and reversed 5. In all 5 of those, there was no dose estimate. In the one case where it did not reverse, Sassone, there was a dose estimate. There was no issue of
That came from the defendant's experts in Sassone, correct?
Yes, it did. It was from defendant's own IH. So the defendant conceded a lifetime cumulative dose of 0.7 fibers per cc. The issue of fact was, is that amount causative? The issue of fact wasn't how much exposure was there. Is it a causative level?
Right.
Completely different from the other 5 cases. This case fits squarely in with the other 5.
All right, you'll have time on rebuttal.
Thank you.
Good afternoon, Your Honors. Pierre Ratsky from Whites and Luxembourg for the respondent. First, this case is just like Sassone. The plaintiff's experts in that case.
No, it's not.
Okay, the plaintiff's expert in that case did not have a cumulative dose. That's not true. And there's nothing in the decision that says that, that the defendant's
Every
expert's
case
expression.
where we have upheld denial of summary judgment, there has been evidence in the record to at least estimate what the exposure was. There was an expert who said that level of exposure is sufficient to cause causation, et cetera. We don't have that here.
Respectfully, we do, Your Honor. It's the same opinions. It's the same studies of Donald Durham's rock hard water buddy. And at .36.
Yes, but I have no facts from your plaintiff.
We do
May
have
she
facts.
rest in peace. We have no facts. Her ex-husband said, I don't know, I didn't use it every day. I don't know how many times I used it. I don't know how many times she was exposed to it. I mean, there was nothing consistent. It wasn't like he said, oh, for 15 years, I used that product every day and I sanded it down and it's, rained dust on me and I had to go home and my poor wife had to clean it in the laundry. None of that.
He said that he used it. It was always in his toolbox. It was one of the items I carried all the time. That's 197.
Yeah, in
23
the
years.
toolbox, counsel. Why do I care that it's in the toolbox?
Because he used it outside of his home all the time. But the home renovation.
I need evidence in the record that he used it on a consistent basis and show me how your use of it, because his wife wasn't on the job with him, right?
Yes, there's 2 different forms of exposure here. For the home renovations, he was specific about how many home renovations it was, how many nails he filled in. That is actually specific testimony. And he said that he used a whole can in at least 2 of those home renovations. So that's some basis for an opinion.
So where is the specific lifetime exposure from that, from the putty?
Well, there's no lifetime exposure.
Right.
Cumulative
Okay.
dose
So
on this.
So Nebeth says you need exposure, and to show that the amount of exposure is sufficient to cause the mesothelioma.
Correct. And this
right?
the same evidence we have here is what we had in Sassone. They do not have a cumulative dose, so they have not met the burden.
Well, again, we don't agree with that, or I don't agree with that. But what is it that you are saying? What evidence of her specific exposure do you have? Other than he kept it, not what the ex-husband did is one thing. It's how she was, what evidence do you have of her cumulative exposure?
That she was always nearby when he did this work in the home renovations, so that he gave him.
I don't
he gave
think
him a
that
hug
was the
every day
testimony,
when he
but
came
okay.
home. That she shook out his laundry. That she did his laundry almost all the time.
Yes,
she
but
vacuumed
that
up
doesn't
after the-
connect to the putty. It connects
Correct.
to a lot of other things, but not the putty.
No, it does connect to the putty because this was part of his home renovation work, where he said that after he would scoop the putty out of the can, it would get dust on his clothes, it would get dust on the floor. She was nearby when he did that work, and that she cleaned up afterwards. And
You don't get dust from putty until you sand it.
no, that's not true, Your Honor. And there's
Okay.
industrial hygiene studies of the putty
All right.
showing exposure from the dry powder. There's also industrial hygiene studies from sanding. He used both sandpaper and a power sander. And those industrial hygiene studies have people, as counsel pointed out, both doing the work, which is relevant to dust falling onto his own clothes, but also people standing nearby. And those people standing nearby have cassettes on their lapels measuring inhalation levels. That's the same evidence we had, the same kind of studies we had in Sasson. There's no distinction here between Mr. Garza's report and Dr. Ginsburg's report from Sasson. We did not have a
You
cumulative
keep
dose
on
there.
saying that, except that it's not just the experts' studies that we consider, right? It's also the underlying facts of the actual case. And so the facts in Sasson are very different from the facts in your case. So while the studies may be the same, their application to the facts in this case is not the same.
Two points, Your Honor. One, all of these criticisms of the facts come solely from Durham's attorney. There is nothing in their expert reports that say the facts are shortcoming because of XYZ factors.
No, because their expert doesn't believe that you've even shown that there was asbestos exposure.
And-
So why would they say anything else?
If they've met their
So,
burden on
the
that,
fact that they didn't say anything like that is irrelevant.
if they've met their burden on asbestos content, we've fully rebutted that with a scientific record, with Dr. Weber's reports, and Dr. Compton's
You
bulk
still
analysis.
have your specific causation problem, which is that I'm looking at the testimony. He didn't think he used that putty that much. He didn't give it much thought. I don't know how you could, on that testimony, find specific causation.
I would just note that there's nothing in their expert reports about take-home exposure at all. All of these criticisms about the supposed shortcomings because this is secondary exposure come solely from Durham's attorneys. It's a classic case of trying to point to gaps in our proof. If they've met their burden on general causation by showing that it doesn't have asbestos in it at all, we've rebutted that. They have not met their burden on specific causation, and we think we've rebutted that as well. But if Your Honors are unconvinced, we're not required to rebut something on which they have not met their prima facie burden.
Thank you.
This
You may
case is not
proceed.
just like Sasson. This case is not just like McWilliams. First of all, in Sasson, the studies at issue here, Dr. Compton's and Dr. Dotson's studies, hadn't been performed when Dyke Lumber moved for summary judgment in Sasson, if my memory serves me. Those studies were not at issue. They weren't relying on Dr. Dotson's study. It hadn't been done. And Donald Durham was a defendant in Sasson, and I was trial counsel, so it's apples and oranges, those two cases. As for the nail holes, yes, he did say he used Durham putty to fill in nail holes and 50 nail holes and 10 knot holes. There's no testimony about whether she was nearby. There's no testimony about whether she was around. She did say, pardon me, Mr. Brzezinski did say that Mrs. Brzezinski tended to vacuum, but he admitted that that pretty much captures all the dust. And there were no studies about vacuuming. There's also no studies about release from laundry when that clothing has been contaminated with Durham putty.
Was there any expert opinion about what level of exposure, even assuming that she had been standing right next to her ex-husband when he puttied all 50 of those holes? Was there any evidence in the record that would support that that activity, the puttying of those 50 holes would have been sufficient exposure for the causation of mesothelioma?
I don't believe that Dr. Compton or Dr. Dotson's studies pertain to filling in nail holes. I believe they pertain to filling in much larger holes. However, I'll concede that Dr. Compton's study does include standing nearby during sanding. The problem is we still have that, what appears to be that miscalculation. We still have the miscalculation of the 0.36. Pardon me. Reminder to pick up my son from school. I apologize. So we still have this issue of they're all relying on this 0.36 figure. Now, Mr. Ratsky is criticizing me for filling in gaps on behalf of my experts, but he has to fill in the gap for his experts to make up for the 0.36 that doesn't add up based on basic multiplication.
Thank you.
Thank you.